the expressway will dive into it and transition to a beltway.
All right. Well, let's talk about an eminent domain case from start to finish from a landowner's or a business owner's perspective. Again, we've been focusing on Wekiva River Parkway, but there are big eminent domain cases going on over in the villages and Palm Bay. You mentioned some different highway projects. Remind me what those projects are.
Well, you have State Road 48 in Sumter County. You have I'm working on 436 and 1792 in Seminole County. You got other projects that out there, Hoffner Road in Orlando, both east and west of 436. You have projects that are out there, Interstate 70 in Sumter County as well as in Marion County, and you have various billboard acquisitions the DOT is doing on I-70 and I-95.
Okay, so then let's start from the homeowner's perspective, and it starts by one day you get a letter in the mail, and it's coming from the city, from the county, from the state. I'm sure it looks official, but what would that, if this was the first letter that a landowner was to receive, what would that letter say?
The letter will say, typically from an appraiser, saying, I'm going to come to inspect your property, to do an appraisal of your property on behalf of whatever condemning authority.
And what would a typical homeowner's response to that be? Would they, from your experience, would they be curious? Would they throw it in the trash? Would they call the lawyer? What would happen at that moment in time?
Well, what they need to do at that time is contact a lawyer at that time, because I've had clients of mine talk to the appraisers and talk to and all of a sudden it won't just be the appraiser shows up. The government will send 7 or 8 different people there, the engineers, attorneys, all kinds of people, and they'll basically, investigate your property thoroughly. And at that point, and many times I've had clients not unknowingly tell them certain information that proved to be incorrect, and then later on it caused some issues with evaluation. My advice to everyone is that when you get those letters, is consult with an attorney immediately and determine whether or not you will attend the inspection or have someone else attend on your behalf.
Well, while we're on that point, I want to make it clear to the listeners out there, and that is this, is that if the government is going to take your property or take your business, you as a owner of the land have a right to hire an eminent domain attorney, and in fact, the government pays that your attorney's fees, if I understand it right.
Yes, under Florida law, it says that the government must pay the landowner's attorney's fees and business owners' attorney's fees, so that you're on the equal footing with the government. And some lawyers don't require a percentage. My firm, we strictly work under that premise that our clients pay none of our attorney's fees and are paid by the government at the end of the case from a separate set of money. And if we can't agree on with the government as to what they're going to pay our fee, then a court sets our fee.
So as far as a homeowner or landowner getting this letter in the mail, hey, we're going to take your property, no reason for them not to call you right away, because it's not going to cost them anything in an attorney's fees.
Yes, we have free consultation. As a matter of fact, we prefer to go to their house we bring our own cameras and we interview them and go over and we'll explain the process to them and what happens and what they should or should not do.
At that moment in time, let's just say that you meet the homeowner at their house and the homeowner says, Tom, I see you, I hear you, I like you, I trust you, I want to hire you. At that moment in time, do you make some kind of an appearance in a file of this eminent domain action that from then on they are not to talk to the homeowner, they are going to talk to you, or does that come at a later date?
I can at that point in time. We sign an engagement letter, and then we also sign what we call a owner's authorization form, and then we give that to the condemning authority, and at that point in time they generally filter most of the correspondence through our office.
And so an eminent domain case from start to finish, from the time that they get the letter to the time that the case might be settled, it might have something to do with how long the project takes, but what would be the typical time frame from start to finish?
A typical time frame start to finish is that once they get the letter, Tom, is that they typically is about 6 months at the latest. When they'll 6 months, the government can acquire the property by court action if you don't settle, and then if you go through a court action and as to acquiring the property, the title, then there's another year period of time to argue about the valuation of the property acquired. So typically, the worst case would be about 2 years down the road after you get that notice, as quick as 3 months after you get the notice to work a settlement.
Okay, so we know the landowner has gotten the letter. We know that they've retained you. We know that the government is already working on appraisers of the property. Does a landowner have a right to get their own appraisal, and does the government pay for that?
Government pays for that appraiser as well, and I will get with the landowner to determine which appraiser to hire on their behalf. And so I'll know which appraiser to pick and which ones to avoid. You typically want an appraiser who's willing to sit in a deposition for 3 hours and getting asked a lot of questions by the government's attorney. And not every appraiser wants to do that, and not every are very good at that. There's a few there's several that are very good at that. We know which ones would be appropriate on which cases.
And then, just out of curiosity, the government has their appraisers, you have your appraisers, and just from out of the gate, how far off are those two appraisals typically? I mean, are they just in totally two different ballparks, or are they kind of in the same ballpark?
Tom, that's why you have lawyers. I have one case where the opposing attorney just he marvels that we can be so much above the government's number. And frequently, most of the time, you'll see on a residential case, a strip take, that the landowner's claim will be sometimes 3 to 5 times more than the government's claim. It's been an example of our firm because the government's attorneys, appraisers don't value certain damages. So it varies per case, but on the typical strip take for a landowner, you see the landowner's claims typically are 3 to 5 times more than the government's initial offer.
And are we talking about mostly residential, or are we talking about commercial when we say that?
That would be a strip take for residential. And in commercial, it varies. Tom, it's really hard to say, which one it is. Can I go back one thing? I'm going to make a point, is that the reason why you want a lawyer in eminent domain, if the government gives you a